My name is Hampton Macbeth, and I'm a staff attorney at the State Impact Center. My chapter focuses on the National Childhood Vaccine Injury Act, which grew out of events related to the tragic injuries and deaths of young children who had received mandatory vaccines in the 1980s. News coverage of these injuries led to a flurry of tort lawsuits against vaccine manufacturers, unpredictable outcomes for these lawsuits in court, and vaccine manufacturers hiking vaccine prices or exiting the vaccine market in response to these lawsuits led to a push for a legislative solution to this vaccine crisis in the NCVIA. Under the statute, instead of pursuing tort claims against vaccine manufacturers in state court, victims' claims are handled through an alternative resolution process, the no-fault Special Master Administered National Vaccine Injury Compensation Program. The program was supposed to provide a quick and predictable method for compensating vaccine victims while reducing manufacturers' exposure to tort lawsuits in order to keep manufacturers in the childhood vaccine production market and to keep childhood vaccine prices low. The program's central innovation was the creation of the Vaccine Injury Table, or VIT. If a vaccine victim can show that his or her injury is on the VIT, the claim is treated as an on-table claim, subject to a more favorable causation standard than off-table claims. The special master assigned to the claim applies the relevant causation standard to determine if the petitioner is entitled to compensation under the program, and if so, the appropriate level of compensation. The statute has had a mixed track record upon implementation. It has succeeded in reducing tort lawsuits against vaccine manufacturers as was intended. It has lowered transaction costs associated with providing compensation to victims, and was designed with sufficient flexibility to handle events unforeseen by Congress and the statute stakeholders in the 1980s, such as dispensing with a flurry of claims that a vaccine caused autism and the addition of the seasonal flu vaccine to the VIT in the 2000s. The statute has also had its shortcomings. The program moves slowly, even compared to traditional tort claims, as Department of Justice attorneys representing the Department of Health and Human Services as respondent, as required by the statute, have aggressively contested petitions. A majority of petitioners received no compensation for their injuries due to HHS modifications to the VIT in the 1990s that have transformed the program into an off-table program with higher causation standards. And the process for determining the level of compensation, if awarded, is also slow. Ultimately, this raises the question, was the pre-NCVIA tort system a better method of compensating vaccine victims than the statute itself?